Another thing that we've seen a lot are these AI note takers.
Mm.
And those are also something to be really careful with, especially from a legal privilege perspective, because you want to make sure that you're not inadvertently giving access to information that you wouldn't want to have access to.
This is the Angel Next Door podcast, where we will talk about all things angel investing. What it is, who does it, how do we find them, what does it mean to invest in an early stage company? If you have ever wondered how you can affect the change you want to see in the world, then tune in to learn more. In this episode, I'm talking with Meredith Haviland, a partner at Foley Hoag. We dive into the legal essentials every founder and angel investor needs to know, from the pitfalls of DIY legal work to the reasons investors insist on C-corp structures. Meredith shares practical advice on company formation, equity, board governance, and what happens when your business catches the attention of acquirers. Wondering how to navigate securities laws or if AI can replace your lawyer? Get the answers plus hidden gotchas that trip up startups at every stage. Listen in for actionable guidance to keep your company's house in order and to avoid costly surprises down the road. Enjoy the show.
Meredith, welcome to the Angel Next Door podcast. Hey, Marcia, I'm thrilled to be here.
I am thrilled to have you here talking about all things legal and all things that Foley Hoag does. No, there are so many topics that we're going to be covering today. Everything that angel investors should know, everything that founders should know. So start off, tell us a little bit about your background and about Foley Hoag.
Sure. So I'm a partner in the corporate group at Foley Hoag. We're a full service law firm that focuses on serving clients in the innovation economy. Think life sciences, tech, energy, private capital, what's happening next. And among the clients that we serve are startups and investors in those startups.
Nice. All right. So I know the number one thing when I talk to founders, and whether they're even fund managers or whatever it is, but mainly founders, they talk about, I think I have my documents all set up right, but I was using my brother's best friend, who's a lawyer, who graduated law school like last week, and now we're trying to put all our documents together. And I'm like, oh dear. All right. So tell us a little bit about the actual formation of companies and what has to happen and why it's so important to get it done right from the beginning.
Yeah. I hear that frequently too. And I guess I'll start by saying, and many people may not appreciate that being a lawyer is similar to being a doctor. If you have a foot problem, you'll go to a podiatrist. You're not going to go to an oral surgeon. And it's similar when you think about your legal services. If you're working on a startup company, you want to make sure that you're going to someone who understands that, who understands the path that you want to be on and knows what you need to get done and when. So from a startup perspective, what we commonly hear too are founders saying, well, I only have a little amount of money and legal to me just doesn't seem like the place to spend it. And I think that's just not true. As I mentioned, we do work with investors as well. And one of the things that investors are going to be looking to confirm when they invest in your company is that your house is in order, that you have the right corporate formation documents, that all of your equity is tied up, and that there's no questions about who owns your IP. And I think the key to that is really finding a lawyer that you trust and that you can work with to ensure that you're getting done the things that you need to get done as a small startup company and able to work with you to understand what that is, as opposed to doing everything you might need as a company that's about to go public. And there's a big, wide spectrum there. And so really finding the right legal counsel is important.
Totally. Okay, so let's unpack a little bit of that with the idea of, let's start with setting up the company. They have to make sure they're incorporated properly. And so a lot of times I know companies will start as an LLC and then they'll say, oh, I'm going to go ahead and convert to a C-corp later. So talk a little bit about that.
Yeah. The main difference between an LLC and a corporation is a tax one. And so as an LLC, the entity itself doesn't pay tax and the owners of that LLC benefit from the profits and loss from that company. And if we're talking about an early stage company, likely the losses flowing through to their own personal tax return. So a lot of founders think it's more tax efficient for me to be the owner of an LLC than to be the owner of a corporation, which would pay taxes and the losses would go to the corporation. So while that is true from a tax perspective, from a corporate and investing perspective, most, and I will say most because there are some companies that should be LLCs, but most venture-backed companies will need to be a C-corp and will not receive funding from angels or venture capitalists until they are a C-corp. And so if that's your plan, it's really important to get there, in my view, as soon as you can. So it's important to consider, is it worth me being an LLC for a short period of time in order to potentially benefit from the losses there? Or should I just switch over to a C corporation from the beginning and make sure everything's in order and not have to worry about the conversion, which can be more complicated than some people plan for?
Oh, totally. And the other thing I don't think founders are always thinking about is investors really don't want to invest in an LLC because it passes through to their taxes also, right?
Yes, that's a good point. So that's the reason that a lot of investors don't want to, because then they're getting allocated profit from the company if it's doing well. And while that may sound like a good thing, it doesn't mean they're necessarily getting the corresponding cash distribution to pay the taxes that they will now owe based on that flow through of profit.
Right. Okay, so then let's talk a little bit about equity and giving out equity, how that works, when they should be doing it, and what happens once the company starts to actually have some level of value.
Sure. So equity is the ownership interest in the company. And so I think it goes without saying, but it's very important to know who owns your company. So you understand when you are doing distributions or when you sell, who has a right to those cash distributions and profits and the sale proceeds. Generally speaking, again, if we're talking about a corporation, those equity interests are stock in the corporation. And the stock can have different terms, but the key is that anybody who gets stock, it needs to be issued in the right way. You have to have the board approve the stock issuances. And you want to make sure that anybody that you talked to about getting equity, that grant is appropriately documented. So if you're sitting at dinner and Uncle Joe tells you that he really wants to give you $5,000 in order to support your startup, it's very important to clarify with Uncle Joe, is he making a gift to you? Is he making a equity investment in your company? Is it a loan that he expects to be forgiven? And Uncle Joe has the best intentions, but if you have that discussion in 5 years when your company's doing really well and looking at an exit, he may have viewed that contribution as something different than he did on that evening at dinner.
Oh, yes, that is a very good example. And then let's talk about founders, co-founders, and some early employees and how do we paper that?
Yeah. So the important thing is that you are papering it. And so if you're a founder with a co-founder, you want to make sure that the stock issuances to you both have the appropriate backup. So the board consents, the issue documents. You want to make sure that to the extent that there are agreements among the two of you with respect to, let's say, vesting or what happens when one of you leave, you want to make sure that documentation is also in order. When I talk about vesting, that's talking about if you get the equity, you can subject it to vesting such that while you have the equity today, if you leave before a certain milestone, usually time-based, that the equity that has not yet vested would be forfeited or bought back or whatever the conditions may be. And that's important to make sure you document correctly because, again, if someone leaves, you want to make sure there's an understanding of how much commitment have they made to the company and do they need to give back the equity so that you can reissue it to someone who you may need to hire in their place. The one big tax gotcha there is if you are issuing stock that's subject to vesting is you do want to make sure that you file your 83B election on time. And that has to be filed within 30 days of the grant. And that's one that really, if you miss that deadline, there's no going back. So want to make sure that you're doing that correctly.
Right. Yes, I've talked to way too many founders and early employees, and they're like, "In 83 what?" And I'm like, "Well, how long ago did you get the grant?" I was like, "Last year sometime." I'm like, "Ugh." Call Meredith. That's always my answer to everything. Yeah, call Meredith. I don't know what to do there. Yeah, that can be a big problem. Now, what happens though once the company actually starts to have value and now you're thinking, oh, I want to hire this person and I need to create an option pool or like at what point is it good to do that?
Yeah. So it's never too early, in my view, to create the option pool. Just because you create it doesn't mean that anyone has been granted the options. And it's important to get the right documentation in place because, as many people will know, there's different types of options that have different tax treatment, like an incentive stock option or ISO, or a non-statutory option or NSO. And if you're going to issue them to your employees and want them to get the right tax treatment, they have to be approved in a particular way that aligns with the tax rules. In addition, you want to make sure you're granting the options. The board will need to grant them, and you want to make sure that happens. And a key piece to that is what is the value when that option is granted. And so that value has to be fair market value at the time of the grant, or not less than fair market value at the time of the grant. And so the options that are issued very early on when you first start your company, when you're first forming it, if everything goes to plan, will be have a lower strike price, as they call it, because the value of the company is lower than later on when you might be issuing stock once there's value. And the key is that it has to be issued at that. It can't be lower than that fair market value strike price.
Right. And then, yeah, this isn't a tax clause.
Yeah.
We're not gonna go down that road. But just explain if a company does have to get some type of valuation, explain what a 409A is.
So a 409A, the reference is to the tax code reference, which is why it's called 409A, is a type of valuation that can be done. And if it's done in compliance with the 409A kind of rules, then it's generally considered fair market value and protects the company and is a good sign for what the fair market value actually was, as opposed to the board just sitting around and saying, I think the company's worth $5 million today and we'll act according to that. Instead, this is a valuation that you can get done that will then comply with those requirements and allow you to rely on that. And future investors and potential acquirers will want to see that's been done.
Right. So while we're talking about potential acquirers, what are some of the mistakes that you've seen people make that you're trying to help them avoid when it comes to, okay, wait a minute, now it looks like we might have somebody who's interested in buying our company, want to go look at the deal room and what's going on?
Yeah. So when we're talking about early stage companies, and again, someone looking at the deal room could be your first round of investors, so it doesn't necessarily have to be as late as an acquisition. We already talked about some of the equity pieces, and so you'll want to make sure that anybody who's entitled to equity, that documentation is in place and that there's nobody kind of out there that you haven't documented that with. For many startup companies, their IP is the key to their success, and that's another one that you're going to want to make sure is all buttoned up. And that means making sure everybody who's touched your IP has assigned the rights to that IP over to the company. That includes the founder. So making sure, again, that the company owns and has the rights to the IP so that as people are valuing that, they know that there's no issues there. And the issue that can arise sometimes is there could be an early developer in the company who has left, and the company didn't have a system in place for collecting those assignment of inventions over to the company. And now you have to chase somebody potentially around the world and ask them to sign over their rights to the IP in the company. And maybe when it has some value that they'd be interested in.
Ooh, that doesn't sound very nice. Yeah. Right. Okay. So while we're talking, you mentioned a couple times about getting board approval. And so let's talk for a couple minutes about governance and how important that is.
Yeah. So as a corporation, let's assume you're in Delaware, although I think this is probably true in every state, the corporation will need to have a board of directors. The board of directors can be as few as one or as many as you decide. For many startup companies, starting with one director who is the founder and also the officer of the company, that makes sense. But as you grow, you will want to take advantage of having other people on your board, and investors very well may require that other people sit on your board. Once you start having, for any actions, even if you're a solo director, there are certain things board will act. You want to make sure that action is documented and that it's included in the records of the company. So again, if you're trying to figure out who owns what stock, someone could go back through the records and say, okay, I was able to see Marcia got her 20 shares on this date and Meredith got her 20 shares on that date, and that's all reflected in the cap table. Once you have other directors, they will come to the table. They'll need to be part of those discussions. And to the extent that, you're acting, the bylaws will tell you what the thresholds are, but most often it's a majority of the directors need to approve any action in a meeting. Most often, boards act by written consent, which will require unanimous consent. And from a practical perspective, most companies, the board is all in agreement with any action that's taken in any event, because typically if they're not, there's a discussion and people work out what that issue might be before the action is taken. So it's important that you document all those actions. It's important that those do get kept in the records of the company. It will be part of diligence that people are looking at. And the other thing to note, if you are on the board, is that as a board member, you owe your duties to the company and to the stockholders. So to the extent that, for example, you're an investor and also on the board, when you're acting in your capacity as a board member, you need to be thinking about the interests of all the stockholders and not of you as an investor and what your personal situation might be.
Yeah, that's so interesting. And then so the all of the documentation then you're writing that up for each of the board meetings and then all of the things that actually are happening that would need to be voted on. How do
Yep.
you know exactly what do we need to vote on, what don't we need to vote on? What
So that's when you call your friendly corporate attorney.
That's right.
But
That's when you call Meredith.
yeah, there are certain actions that the Delaware Code will require that the board act on, and effectively major decisions, you should have a board approval record of that. Stock, you definitely need it. If you're going to do any sort of acquisition, if you're going to do, think of all the major actions you might do. A lease, frequently people will want to have the board approve that. And again, it's appointing officers, your board will approve that. And then I just should, as a footnote, some of the actions also require stockholder approval, but we're talking about the board. And so the key is just making sure that the board is involved in any major decisions related to the company.
And so tell us a little bit. So you mentioned that a board member has the fiduciary responsibility for all shareholders, not just themselves. In order to protect them, there's a thing called D&O insurance. So talk a little bit about that.
Sure. So you can, as a company, that you can obtain director and officer insurance, and it will cover any liability that the director or officer may incur, provided that it's done, that the actions are taken and the director is acting in good faith and abiding by the law and not doing anything fraudulent. And then that way, to the extent that there is a lawsuit filed against the company or against the director in their capacity as a director, that insurance would help cover the cost of any potential liability.
Right. Okay. Yeah. D&O insurance. Make sure you have it before you become a board member. So talk to us a little bit about, okay, now the company's gotten big enough. They want to go raise money and they need to first they need to decide how they're going to raise money. But let's say they're going to actually try to raise a priced round. How do they submit to the SEC? What kind of offering are they doing?
Yeah, good question. Just taking a step back a little bit, and in the United States, the securities offering regime basically has, the way I like to think of it is there's a presumption that when you offer a security that it needs to be a publicly listed security. And the way that you get out of that is by finding an exemption to rely on so that your company does not need to be publicly listed, the big like IBM or Apple or whatever. And so one of the exemptions that most startup companies will look to is Rule 506 under Regulation D. And that allows you to not make a public offering and comply with all those requirements, provided you comply with those rules. And among those rules are offering to accredited investors and selling to accredited investors and making what are called Form D filings with the SEC. And then the states also have their own securities laws. And the way that if you're relying on Rule 506, then the states, there's a lot here, but the states, you would make a blue sky filing is what it's called. And it's basically filing with the states a copy of your Form D and a fee where it's required.
Right. And so if you have investors from 10 states, then you need to file in those 10 states. Is that right?
That's generally correct. There are exemptions in some states, and sometimes your attorneys will talk to you about those exemptions, particularly where you may have missed the filing deadlines. But what's important to know is that you need to understand when you're selling in different states that those states have their own regulations. And if you rely on Rule 506 and meet the filing deadlines, that's the easiest way to comply. There are exemptions in the states that may not require that filing, but not every state has such an exemption. And so it's just important to be aware of the requirements to comply with these laws and understand before you go into offering mode how you're going to comply, because it impacts who you might offer to, how you might offer, and it also future investors are going to be looking to see that you complied with these. And if you miss some of the deadlines, it can be very difficult to rectify.
Right. Yes. So, yeah, all of these things that need to be thought about beforehand. But what happens when people realize, well, wait a minute, I didn't know about that. I know that I didn't know about that is not a good excuse for many of these places. So are there ways that you can go back and try to rectify this, especially if the company didn't really know they were supposed to do it?
You can I guess I'd say it depends. It really does depend on the facts and circumstances. As I mentioned, there are some offering exemptions that don't require filings in some states. There are some limited ways. And if you happen to fit within one of those situations, then, it might all be okay. It's also, again, it just depends on what the situation was. And it's something you should just talk to your lawyer about.
Yeah, and it's always better to have it done right from the beginning.
That is
Why
true. Because
you should
again,
be
most things you can figure out, but sometimes there's not a clean way to undo something that was already done.
So I think one of the rules that a lot of founders don't know about and think is ridiculous, but either way, it's a rule, is they think they can just talk to anybody and post it on social media and talk at length about how they're raising money and they have a securities offering to sell equity in their company for money. And I'm always like, oh no, you can't talk about that publicly like that. Talk a little bit about what we call general solicitation.
Sure. Historically, it's always been the case that if you want to rely on Rule 506, then you would not be able to engage in the type of behavior you were mentioning or general solicitation. And instead, the offering would need to be limited to people with whom you had a pre-existing substantive relationship. And that was to avoid situations where you might call up somebody who wasn't an accredited investor and tell them about it, and then they would invest. And it was not viewed by the SEC as the appropriate way to offer these private securities. A number of years ago now, the SEC has come up with a way that you can do a private offering using general solicitation, which does sound a bit counterintuitive. But in fact, you can. The issue is, whereas if you do it in a true private fashion without general solicitation, you can rely on information that people are giving you, provided you don't know that's incorrect. So if someone says, yes, I'm accredited and here's how I'm accredited, you have a reasonable belief that's true, you can rely on that. If you, in fact, engage in general solicitation, the SEC requires that you take steps to verify that someone is accredited. And so while that can be done, it does require an additional step. And to the extent that person might be an individual, it will require some way of you confirming their either net worth or annual income, which some investors don't really want to provide or deal with. And so at that point, you may have limited your options from an investor perspective.
Right. Yes. I've heard that many times. I have heard a couple people, especially recently, since the age of AI is upon us, say, well, I don't really need a lawyer because I'm just going to use ChatGPT. What are your thoughts there?
Yeah.
Which scares as an investor, I'm like, please don't do that.
Yeah. Yeah. AI is a great tool. And it's out there for all of us to use, including us as lawyers, to help cut down on process, to make things more efficient. When you run something through ChatGPT, they're going out to all the various public sources, whether or not those are reliable, and pulling together the response for you. Pre-generative AI, when we might do a Google search, I think everyone intuitively knew, well, I can see what's out there. Maybe I'll get some good background information. But at the end of the day, I can't rely on Google. And I'd say the same is true for ChatGPT. You can get some great information. It can be great to provide some background. But there are a lot of nuances, and not just the law, but in the law, as if that's what we're talking about, where ChatGPT may tell you how to do something and doesn't quite have it right based on the information that they're pulling and sourcing from. And so it's really important that we engage with and use AI as an appropriate tool, but you also need to make sure that what it's telling you is correct. And the people who will be able to give you that guidance are the lawyers.
But there are specific AI tools that you as lawyers can use, but you're not just using some tweaked version of ChatGPT, right?
Yeah, well, and it's a little bit, there's a few different issues when we talk about AI. So one of the issues is, are you able to rely on what they tell you? And even the AI tools that we use as lawyers, we need to make sure that we're supervising them, monitoring them, that they are giving us the correct information. So again, it is a tool and it helps with efficiency, but it is something that you need to make sure is still giving you the right information. The other issues with AI include things like if you're uploading your information to ChatGPT or some other software that doesn't have appropriate confidentiality walls and restrictions on it, you may be putting your confidential information out into the public or into a tool that's then going to learn from it. You may be breaching some confidentiality requirements by doing that because now that third-party software is going to retain a copy of it. And so you do want to make sure that you're appropriately using AI and that the appropriate, if you are putting confidential information into whatever AI program it is, that you understand what the arrangement is or the license is with that software with respect to your confidential information. Another thing that we've seen a lot are these AI note takers. And those are also something to be really careful with, especially from a legal privilege perspective, because you want to make sure that you're not inadvertently giving access to information that you wouldn't want to have access to. And so generally speaking, best practice is to not use, and just like you wouldn't necessarily record a full board meeting before this with a tape recorder, not to use the AI note takers and to instead just make sure that when you're using them, you understand the limitations and that there's not information being shared that you would not want to be shared.
That's such a good point because I've gone into meetings and then so-and-so who isn't even there, they're note takers there. And I'm like, wait a minute, what's happening here? And it's like they're sending the note taker so they don't have to be in the meeting. But then what if something is discussed that was confidential and now it's on some note taker out in the ether?
Yes.
Right.
Again, it's just really important to make sure that if you do have a note taker present, that you've taken all the appropriate precautions. Everyone understands that and you know the limitations of that. But again, a lot of times best practice is to just not use them.
Right, right. I also get super nervous when I think about the founder who has some really significant IP and it's not protected, or maybe it is protected because we didn't even talk about what you have to do in order to protect your IP. But like then they put it into AI of some version and now it's out there and it's learning and it's telling other people to do whatever type of thing with this knowledge. In a lot of cases, there are companies that have a lot of money, right, to defend their intellectual property. But even if you own the patent, doesn't mean you have the money to defend it, right?
Yeah. And it's also, you asked me earlier about getting ready for sale or things that might come up in investment. And these are questions or representations that more and more investors or acquirers are going to start asking about because of the risks associated with it. And they'll just want to make sure that you have appropriately protected your IP, including in respect of AI, and understand how you've been using AI. And it's important to be able to give those representations. Otherwise, you may not be able to get the investment or it could upset the transaction.
Wow, that's a really good point. So investors and potential acquirers are starting to ask, hey, how are you using AI in your business? And how much of that has gone out into helping train or other AIs learn?
Yep.
Wow. Wow. Well, Meredith, you are a wealth of information. You've given us so much today. At the end of the day, where can people find you?
As I mentioned, I'm a partner at Foley Hoag, and so people can feel free to reach out. My email address is mhaviland@foleyhoag.com.
Great. And we'll put all that in the show notes. And like I said before, when you have issues, what should you do? Call Meredith.
Oh,
Thanks, Meredith,
thanks
for
so
being
much,
on
Marcia.
today. Thanks for listening. To connect with me, visit my website at marciadawood.com. And please subscribe, follow, and leave a review. It helps the podcast get seen by more people. And remember, you can also find the Angel Next Door podcast on YouTube too. And if you're looking to learn more about investing in the changes you want to see in the world, sign up for Ann and Bill Payne's ACA Angel University classes. Go to theangelcapitalassociation.org, all one word, to find out the schedule. And classes are now available on demand. Many classes are offered, everything from angel investing basics, which include fundamentals, risk, due diligence, term sheets, valuations, returns and portfolio strategy, and even a class on group formation. There's even a deeper dive where you can get advanced classes, including capitalization tables, startup boards, and exit strategies. If you're not already a member of the Angel Capital Association, you can become one for a low price that will give you unparalleled access to discounts, free webinars with a huge archive of content, networking opportunities, and much more. We'd love to have you join us. All content for this website is informational and not intended to serve as legal, tax, accounting, or investing advice. While Marcia, that's me, does serve
on the SEC Small Business Capital Formation Advisory Committee. My views are my own and not the views of the SEC or my fellow colleagues on the committee. Our speakers and hosts are thoughtfully selected for their educational value, but their opinions are their own and do not necessarily represent the views of the host, me, or the Angel Capital Association, and neither specifically endorse the use of presenters' products or services. Listeners of the podcast should consult their own tax, investing, legal, or accounting advisors before making important financial decisions. All warranties, including accuracy, completeness, and suitability for specific purpose, are disclaimed.